think it is 12:01, so maybe let's go ahead and get started. Thank you so much for joining us here today. And especially if you're a donor and a supporter of MCA, we're grateful to have you. If you have not yet committed to be a sustaining donor and give monthly, we encourage you to think about that. These kinds of legal cases and these webinars are, this is what MCA does best, and we want to tell you about our work, and we're happy that you're with us today. I'm Catherine Hoffman. I'm the CEO of MCEA, and with me today also are Kevin Ruther, our Chief Legal Officer.
Hi, everybody.
And also Evan Mulholland. Evan is our lead attorney on this air permit case that we're talking about. He briefed and argued it before the Minnesota Supreme Court.
Hey everyone, welcome.
So here's what we have planned for you today. We have about 45 minutes or so. Kevin and Evan are going to walk us through this decision and what it means. You've probably seen the press coverage and realize it's a little bit nuanced. We also want to get to your questions, so we'll make sure to leave plenty of time for that at the end. If you do have questions, please go ahead and put those into the Q&A. We'll try to keep an eye on that. We may even be able to sort of get to those throughout our talk, but that's the best place to put them. If we don't get to them during the talk, we'll get to them at the end. So let's go ahead and get started. So Kevin, I'm going to start with you. Tell us where we're at on PolyMet more generally. I mean, this legal challenge is just one of several. Where's sort of the context of these cases?
Yeah, okay, great. So, well, first of all, I want to say about this case, just so that people understand, I've been receiving all these texts and messages saying like, oh, sorry, what a bummer, when people saw some of the headlines. And I just want to clarify that actually this case wasn't a big loss for us. And I'm really happy that we're going to have the opportunity to dive deeper into it and explain it to people. But the overall message is really for everybody, whether you're a supporter of MCEA and opposed to this mine, or if you're a supporter of PolyMet's, nothing has really changed. Nothing on the ground has changed, right? Because we're in the middle of a number of different challenges here. This is just one of 4 or 5 different cases. I'm going to mention a few of them. So we had a case that was decided by the Court of Appeals on the permit to mine and the dam safety permits. That case revoked those permits essentially. And so PolyMet cannot move forward without those permits in hand. That case is pending before the Supreme Court, and we're still awaiting a decision there. So nothing has changed with regard to that case. There's also a case pending regarding PolyMet's water permit. It's NPDES permit, which is the permit to discharge into surface waters of the state. That case has been stayed by the Court of Appeals. Nothing has changed there. There are 2 other cases that challenge the wetlands permit for PolyMet. One is in federal court brought by us. Another was the case that was brought by the Fond du Lac Band, also in federal court. And you may have read a headline about that case. PolyMet put out a press release saying that the case had been dismissed. In fact, that case, my reading of it was really good for Fond du Lac. There are 9 different counts in that complaint, and only one of them was dismissed. One of them that Fond du Lac survived dismissal on was actually very beneficial to them. And so I think that we're going to be hearing more about that case. So I think overall the message is, nothing has changed on the ground. PolyMet can't move forward. We still have a number of different cases pending. And in fact, this case that we're going to talk about today is still pending. And I think that we're feeling like we're in a pretty good position, even though we lost in this one federal question issue that we're going to talk about a little bit.
Great, thanks, Kevin. All right, so now let's dig into this particular case a little bit. I'm going to turn to you, Evan. Let's start with, so this case is about the air permit. What are the sort of basic facts about PolyMet's air permit that were important for this case?
So here's some of the background on the air permit and what led up to our appeal through the Court of Appeals. So the air permit was issued late in 2018, and it is what is called under the Clean Air Act a synthetic minor permit, which means that if you look at the potential of the plant, the way it's designed, how much pollution we're expecting it to emit, without any controls, it would emit more than what's called the major source threshold. It would become a major source. So what PCA and PolyMet agreed is that they would institute a cap on ore throughput at 32,000 tons per day of ore. And that lowers the amount of the tonnage of emissions that would be emitted otherwise throughout the days and the year. This is allowed under the Clean Air Act. And as we were in the comment period earlier than the permit issuance, we were explaining that one of the key problems with this permit is that the existing plant that is in place has the capacity to process way more than 32,000 tons per day. So it was really important for us to make sure that there was a enforceable cap on that for the air permit to work. So 10 days after the comment period ended, we discovered that PolyMet had filed what we call the technical report. It's a Form NI 43 report through the Canadian Securities Regulations Commission. And that report shows that PolyMet, while the permit was under review, PolyMet was actively investigating the possibility of expanding the plant's throughput to twice and 3 times the 32,000 tons per day. We asked PCA to investigate this problem, and they refused and issued the permit anyway, and we appealed to the Court of Appeals.
Okay.
Can I just highlight one thing that Evan said there that I think is really important? So everybody knows this permit has been, in development, and this project has been in development for literally decades. And what Evan described as the comment period, that's really important. That's like the period when the public, all of us, get to say what we want to the agency that's going to issue this permit. It's when we have to get all of our expert reports in by then. We have to get all of our analysis done by then. And it's usually the cutoff date for the record, what becomes the record for the decision. So the fact that this report, the Canadian report, was issued 10 days after the comment period is striking. The lawyer for PolyMet at the Supreme Court hearing said that it was just a coincidence. But it's hard, sort of from our perspective, to believe that it could be a coincidence that this report would be issued 10 days after anyone was able to put anything into the official record for this case.
Right, because this plant is an old taconite plant that has the potential to have a throughput of close to 100,000 tons per day, 3 times what PolyMet's proposing. And we already knew that, and that's why we put it in those comments. And then when this technical report came out just a few days later, all the red flags were there for us. All right, so how did the Court of Appeals handle this challenge?
So Catherine and everyone, the Court of Appeals had really 2 issues in front of it. One was a federal law issue, and one was a state law issue. And under the federal law, what it means, it's what is called under the Federal Clean Air Act sham permitting. The idea that you're supposed to tell the permitting agency what it is that you're going to build so they can issue a permit appropriate to what it is you're going to build. If you pretend that you're going to build something much smaller, but in fact you're about to build something much larger, that's not right. I mean, anyone can see that. And that's what's called a sham permit. We challenged them under that. And we also challenged, using the same fact pattern, that under Minnesota law, the PCA is required to make sure that the company, the applicant for the permit, discloses all relevant facts and does not submit any misleading information. The Court of Appeals really only looked at the federal law issue, the sham permitting issue, and they decided that they sent it back. We won at the Court of Appeals. They sent it back saying that PCA should have investigated whether or not this permit was a sham. At that point, the company, PolyMet, and the agency, the PCA, appealed to the Supreme Court.
Yeah, and I just want to pause here and say that this federal claim of sham permitting, using it as a legal theory at the point where the permit is issued is not something that any court has ever really had the opportunity to recognize before. So this Court of Appeals decision, was really cool in that it's sort of recognized a new cause of action. And a lot of that was Evan's own experience working in Clean Air Act enforcement with the Attorney General's office and with the state agency in New Hampshire. So he really developed this very innovative and novel theory under federal law, which is also why this was, a tough case for the courts, because we're asking them to do something new. So we have this claim under federal law that was recognized by the court, and then the state claim that hadn't really been looked at yet. How did the Minnesota Supreme Court handle those, Evan?
So this gets to why you're here. What did the Supreme Court say? The question that was posed to the Supreme Court, the Minnesota Supreme Court, was whether the Clean Air Act requires the PCA to investigate whether or not there is a sham permit problem before issuing the permit. And the Minnesota Supreme Court decided that in the negative, that the Clean Air Act does not require the PCA to do this investigation. Instead, the regulations that we're talking about have a retrospective application. In other words, what the court is supposed to, what the agency is supposed to do is look at this from a retrospective analysis. So in other words, when a company goes to expand in the future, the agency is supposed to look back and look at the original permit and decide if it was a sham at that point. But importantly for us and for moving forward, the court also said that PCA had the discretion to undertake that type of investigation at the time of permitting. And they also said that the Court of Appeals did not decide these state court issues that Catherine just mentioned, whether or not the company was misleading in any way in its permit application. So the Supreme Court has sent this question back to the Court of Appeals, and that's where we are.
All right, so the court, go ahead.
Go ahead, Catherine.
Oh, I was just going to
add on.
So the the court basically said, when we wrote this letter to the agencies saying, hey, PolyMet's got these other plans, they're talking to their investors about it, we're concerned. The agency was well within its rights to further investigate and ask more questions of PolyMet about that under federal law. And they may be required to do so under state law. That's the thing that the court's going to have to do. But the agency chose to do neither.
That's correct. Yeah. We think the agency should have done a bit more.
Yeah, I was just going to reinforce that it's a very narrow decision what the Supreme Court actually decided. And it's really limited mainly to this question of what the federal law requires, whether pre-permitting an agency has to look at, has to investigate these allegations. So the court didn't go into the evidence. They didn't really weigh in on whether or not, if the agency had looked at this, what it should have concluded. All of that is still out there for us to fight about at the Court of Appeals now.
Yeah. There was a question in the chat about how much more profitable these alternative scenarios are. I think that's a really important issue in this case. Do you want to say something about that, Evan?
Sure. Yeah, it really depends on the price of copper and the projection on the price of copper. But when you have a plant and you can push more ore through the plant, you have the same plant essentially. You're just doing it faster and more, so you can make more money per unit of effort. So the triple capacity, the triple throughput, is several $100 million more valuable.
Right.
$100 million. It's a lot more money.
Right.
And didn't they talk about the rate of return, that the proposed mine would have about a 10 or 11% rate of return, and these alternative scenarios were way higher? I can't remember how high, but
yeah, it was closer to 25%, I believe, much higher rate of return for the investment of capital.
Right. And what we heard from our experts right away was You know, look, for a mining operation, a 10% rate of return is very poor. Because there's so, you know, if you think about if you're going to go invest in a mining operation, it's very risky because there's a lot of things that can cause that sort of upside of 10% to not happen. You know, you don't get the permit or the court takes the permit away. You know, they know a lot about the ore body, but it's not 100%. So there could be the ore body might not be as rich as they originally thought. Of course, the price of copper can go up and down. So really, for a lot of these mines that successfully are built, the rate of return is more in the 30% range. And so even those like more optimistic or the faster, bigger scenarios in the 25% range, even that's not awesome for the mining industry. But 10% is, you know, pretty bad. So, all right, then, Kevin, that's what the court did. They had this kind of narrow ruling on the federal issue. What's next? Where do we go from here?
Well, obviously, we're still kind of digesting the decision. We're actually going to huddle up next week with our group of lawyers who've been working on this and talk through it. It's interesting because, you know, this narrow issue that I'm saying they made a decision on is a question of federal law. And when state Supreme Courts decide federal issues, there's actually an avenue to have the US Supreme Court review those decisions. So we haven't been in the position since I've been with MCA, very often at least, to really consider going to the US Supreme Court, but we're in that position now. So that's one thing that we'll have to take a look at. There's a 90-day period that we can decide whether or not we would want to seek that review. Otherwise, we're a little bit in a waiting period. I think that what usually happens here is when a court or when a case gets remanded to a lower court, the lower court will issue some sort of order instructing the parties on what next steps ought to be. So I think we kind of expect that the Court of Appeals will be issuing an order in light of this decision. And, you know, obviously we're not going to go into any of our ideas about next steps with any specificity or our legal thinking on this kind of public webinar. But I think that we have a number of options going forward. We will definitely continue to press the claim that what PolyMet has done here is not fully forthright, that they weren't really disclosing to the agency or particularly the public some of their intentions, that they were saying one thing to their investors, oh, we can, you know, increase our throughput because we have this facility that's already set up to do it, and we can make way more money and make our operation actually profitable. On the one hand, and then saying to the regulated party and the rest of us, no, we want this permit with this cap because we only want to process 32,000 tons. And I think that we're hopeful that the Court of Appeals is going to be receptive to that argument. Obviously, they were once already under the federal law, and hopefully they'll take a thorough look at it under state law as well.
Yeah. Well, there's a lot of great questions in the chat, and so I want to get to those, or to the Q&A rather. So if you do have questions, go ahead and put them in Q&A. You know, before we do that, there's one, you know, I do want to pull us out just a little bit from this particular decision and kind of talk a little bit about a theme that I see, you know, a common thread throughout these cases and this litigation that we've had on PolyMet. And I think that the thread that I see is that these cases really raise red flags over whether our state agencies are giving these projects the hard look that they deserve, and whether they're thoroughly investigating the risks of sulfide mining. So if you go back to the Clean Water Act permit case that Kevin mentioned, you know, in that case, you might recall the Pollution Control Agency tried to, and successfully for a while, to keep the EPA's comments from being seen. They didn't want the public to read those, and so they asked the EPA to sort of submit those comments over the phone rather than in writing, so they wouldn't have to go into that record that's part of the public comment period that Kevin mentioned earlier. You know, and the permit to mine and dam safety permits, which are at the Supreme Court now, and we're waiting for those. We asked for a contested case hearing to evaluate some of these risks, like dam collapse and financial assurance, and they refused. They said that we don't need any more information, even though in some cases their own experts had raised concerns about the strategy that the agency had chosen. And of course, in this case, you know, the court noted that under federal law, the PCA could have investigated whether PolyMet was planning to build a bigger mine, and they decided not to. Instead, they decided to litigate that question all the way to the Minnesota Supreme Court. And now we'll be asking the question of whether they were obligated to do so under state law. And it almost seems like that's what the agencies need, is a requirement to give this a hard look, because they're not choosing to do so when there's any kind of uncertainty in the law. So the theme here to me is that, you know, we really do need watchdog agencies like MCEA to keep these agencies accountable, because they aren't really, at least on this issue, they're not doing their jobs. And we're lucky to have the courts that we have to be able to resolve these questions. So that's my spiel about the themes.
Thanks, Catherine.
Should we go to the Q&A?
Catherine, I'm seeing a couple of questions that are kind of related to the record. And there was one of the issues in the case, Evan, maybe you can talk a little bit about, was the motion to supplement or the motion to strike, and what the court allowed to be in the record and what not. And then I saw a question about whether or not that's going to be sufficient for us to make the arguments that we want to now in the Court of Appeals. So maybe you want to address that.
Sure, I'll try, Kevin. So initially, the agency who develops the record, the PCA, didn't put in everything that we thought ought to have been in the record. So we had asked them to put some more documents into the record so the Court of Appeals could look at them. And some of them, the most important one, this technical report that we're talking about with the investigation of the profitability of expanded mining, was in the record from the beginning after we asked them to put it in. There were some other documents that helped explain that we also asked the Court of Appeals to take a look at. And the Court of Appeals agreed that some of those documents ought to have been in the record. It seems like the record issues aren't really that important anymore. I think that the documents that we have in the record now are going to be sufficient for us to be in a good place in the Court of Appeals. I hope that helps. There are a lot of motions on the record documents, but the way it shook out is that the things that we needed to cite are in there.
Yeah. And you know, the challenge, there's some questions about this too, about like, can the court, when we go back on remand, can the court take new evidence? Can they take testimony, things like that? And there are some pretty severe limitations on what an appellate court can do in that situation, right?
Yeah, I mean, the role of the appellate court is to decide whether or not what the agency did was appropriate, legal, you know, whether or not it was arbitrary and capricious or against the law in some way. Mm-hmm. It's not, you're right, whoever the questioner was, it's not the Court of Appeals' role to determine the facts.
Mm-hmm.
Although the Court of Appeals does have the authority to, in certain circumstances, develop the record further by sending an issue down to the district courts. That's exactly what happened in the Clean Water Act case, where we had that 2-week trial on the back and forth between EPA and MPCA.
Right. So the court can sort of order a district court or an agency to go develop the record if they feel they need that. Yeah. There's also a couple of questions here about state versus federal court. And like, if we have a federal claim, why are we in state court? And is one, you know, like, is one more powerful than the other? How did we end up here? And would it be better to be somewhere else?
Well, I'm going to let Kevin answer that, but I'll just briefly say that the way the Clean Air Act is set up is that the states are delegated, meaning that the Clean Air Act is a federal law, but the authority is sent down to the states to issue permits and do enforcement, as long as they're doing it in accordance with federal law at a minimum.
Yeah, and part of that delegation means that we have to go to state court. So with the Clean Air Act, actually the delegation just happened a couple of years ago for Minnesota. Prior to that, we would have been taking this appeal to actually it's an administrative tribunal, the EAB, what does that stand for? The
Environmental Appeals Board. It's inside EPA.
Yeah, inside EPA, which one of the reasons actually that we had opposed delegation was to be able to go to the EAB, because as you can imagine, these kinds of cases are super technical. And so if you have a tribunal that's within an agency where the judges are used to seeing these cases over and over, it's much more likely that you're going to get a good, thorough, well-reasoned decision. It's hard for the Minnesota Court of Appeals to take up the Federal Clean Air Act. I mean, it's a super complicated law. But because of that delegation, that's where we are now.
Okay.
Yeah.
And it's not that one court is more powerful than the other, right? It's really just a question of who kind of has the authority, right? So for example, if the state claim that the court has remanded ends up back at the Minnesota Supreme Court, the Minnesota Supreme Court is sort of the final arbiter on that one, whereas a federal issue could potentially go up to the US Supreme Court, and they're the final arbiter. Is that right?
Yeah, so yes, so even though the program has been delegated, what the state court is doing is interpreting federal law, and the US Supreme Court is always the final arbiter on interpreting the federal constitution and any federal law. So when our Minnesota Supreme Court says EPA's regulations under the Clean Air Act mean X, you know, they're interpreting something that was enacted by Congress and then a rule that was adopted by EPA, and that's reviewable by the US Supreme Court.
Yeah, okay.
How likely it is that they would take a case, you know, they don't take very many cases, so.
Right, right. Although that's true of the Minnesota Supreme Court too, and they seem very excited about taking PolyMet cases.
Yeah.
There's an interesting question about somebody who lived near a wind turbine proposal, and the company changed the proposal to make it bigger and said that was related to developments and technologies. And could a mining company kind of similarly propose one thing and then put another one in? And this question of, you know, can this be remedied later? You know, if PolyMet, because PolyMet has to go through some processes if they want to change their project, came up quite a bit in this case, didn't it, Evan?
It did. They cannot change their plan under their permit without going back to the agency to get their permit changed, right? But I mean, I don't know if, Catherine, you want to talk about the permit to mine, which is a lot less constrained than the air permit.
Right, right. So one issue would be that, you know, presumably they would need to amend the permit to mine to build a bigger mine or to change the rate at which they mined, which were sort of the two things that they were proposing to do in that Canadian Securities Exchange document. And that's, you know, there's some public processes required for that, like comment periods and so forth, but that process is I would say a lot less regulated than getting a new permit under the Clean Air Act.
Yeah.
Is that fair, Kevin?
Yeah, definitely fair. I mean, we're seeing examples of that right now with one of the taconite mines that wants to expand its tailings basin. And, you know, we're really having to fight just to get the DNR to do an initial environmental review about whether or not expanding this tailings basin would have additional impacts to the environment. It was studied, I think, initially back in the 70s, and the first response of the company and the agency was, well, you know, we knew back in the 70s that this was going to be expanded in this way. So yeah, with the DNR permits it's less clear what's really required when a company wants to make a change to their mining plan.
Yeah, yeah. So shifting away from some of the specifics of the case, we have some questions about Well, there's one question about sort of public relations. It says, please discuss the varying PR spins on this decision. And besides PolyMet investors and environmental supporters, are legislative and judicial players also key PR audiences? And, you know, Kevin, you brought up at the beginning that we have had some folks who are confused about this decision and what it means. And partly that's because it's been told in different ways in some different media outlets. We also saw some media outlets that reported it one way, sort of right away, and then kind of came to refine their stories a little bit as they came to understand what the court had actually done. You know, I think that yes, legislative and judicial players are absolutely key audiences. You know, at this point, you know, you're probably not going to influence a judge on like a decision that's before them and has already been argued and briefed. But, you know, it's really important, I think, for judges to judges read the paper too, I guess is kind of the way we put it. And that, you know, environmental law cases, you're often asking a judge to do something kind of unusual, maybe a little brave, maybe a little even countercultural, because these, you know, big projects tend to have some momentum, and people kind of assume if you want to build a big project, you should be able to build it. And so for a judge to, you know, put the brakes on that even a little bit is a big deal. And so it's good for judges to see that an issue is controversial, and that the questions about, for example, the environmental impact of this project have been raised a lot in the public forum by legislators and others, you know, long before this thing ever hit the courts. Is there other things we want to say about the public relations? I do think this is a really interesting question.
Well, I mean, I think I would just say that it's challenging because the way that the media happens now, it's instant. And so if PolyMet puts out a press release saying we won, and it's the one that, you know, hits the desk of whatever Facebook poster or, you know, blogger first, then that's what gets reported. I think that our communications folks did a really good job of getting the real story out. And we were working as fast as we could as well. But I mean, I think, for example, that Fond du Lac case that I mentioned got reported as though their case had been dismissed. And any lawyers on the webinar today, I really commend to you to read the opinion. You will see that actually Fond du Lac came out really on top in that case. And that case is going to be a huge problem for PolyMet going forward, in my opinion. So I don't know, you have to take the headlines with a grain of salt sometimes. And I'm not really sure if there's a good solution for it, just because the timing is so difficult.
Yeah, we've made significant investments in our communications team here at MCEA. And you know, they do a lot of great work, you know, maintaining our websites and social media and letting you all know that this webinar was happening. But they also work with reporters to make sure that our perspective is represented in the public narrative. And that's a lot of work, and it's really important because, you know, I think if we have cases that are wins or that are, you know, a bit mixed like this one, you know, that doesn't matter if it doesn't get told that way. You know, it lets you know, PolyMet claim a victory and say, look, this one claim was dismissed, we win. Well, that's not the end of the story. All right, let's see, what other questions do we have here? There's a question about, do we feel our position in the courts is stronger now than it was a year or two ago? And are we feeling more hopeful about our case against PolyMet?
What do you think, Evan?
I think so. I think so. I mean, what you said in the beginning, Kevin, about the number of cases that we have ongoing that have legs that are continuing on, that we may win entirely. So I think our position in the courts is really strong right now.
Yeah. I agree. There's a couple of questions about like prospective legal changes. Are there things we can do to change the rules or the law? One example is the Prove It First legislation that MCA and our allies at Friends of the Boundary Waters have been supporting. You know, is there an opportunity for things like that to happen? Those are hard. I mean, I would love to say yes. I think that Prove It First has a lot of support in the legislature. And, you know, there's also, we're going to need to get some more votes in the Senate. I don't know if that's going to happen. And the agencies have generally not been really open to changing a lot of these rules around mining.
There's definitely a need to change a lot of the rules around mining. How to make it happen is tricky.
I mean, honestly, these clearly the best strategy we have for strengthening the law right now is the courts, because the courts can, you know, they're helping the agencies interpret these laws. And you know, what we want the courts to do, and what they've mostly done so far, is to interpret the laws more stringently and say, okay, there's some requirements here, agencies, and it's not clear at all that you're following them. The permit to mine and the contested case hearing is a really good example of that, where the agencies said, you know, we don't need a contested case hearing and we have full discretion over whether we ever have to do that. And the only person who can ask for it actually is PolyMet or us. And the Court of Appeals at least did not like that idea and said, no, you really have to look at evidence that's in front of you. And if you have experts telling you there are concerns here, that's a pretty good reason to have a contested case hearing. So, you know, we definitely have courts helping to strengthen these rules in like a court precedent kind of way. But going back and getting the agencies to actually change these rules, you know, I think I like to think that they would consider that after some court losses, but I can't say that for sure.
There are some additional avenues to, I guess we could mention, to trying to urge the agencies to look at their rules. You know, folks can petition for rulemaking, petition for amended rules. There's also provisions in our state law that allow a lawsuit to challenge rules as not being stringent enough or not being consistent with a statute. So yeah, there are some other options.
That actually transitions really well into a couple of the other questions about, you know, what can the public do, which I think is a really good one. One person said, you know, should we just give up on getting good responses when we put in public comments? You know, is that worth our time? Is that just a technicality? And another person asked, you know, how can we pressure our agencies to do a better job? You know, for sure, the agencies gave short shrift to the comments that they got here. But I do not think personally that means it's a waste of time to put in these comments. You know, in the case of the PolyMet comment period, I think this was on their second round with environmental review. So their supplemental environmental review, you know, there were tens of thousands of comments put in, the vast majority opposed to the mine. And even though these agencies might say, well, you know, we don't really have to look at a comment that's pro or for, you know, their boss is the governor. So this is ultimately the governor's call, you know, what these agencies are doing. And you know that on a issue as big and controversial as PolyMet or Twin Metals or Line 3, you know, they're putting that, you know, sending that stuff up the ladder to find out what the governor wants. And so I do think that public pressure matters. And ultimately, it's very likely that these permits are going to end up back in the agencies for reconsideration. And if that happens, you know, this is going to be Governor Walz's call, what these permits look like. And so letting the agency heads know what you think and letting the governor know what you think, you know, it does matter, even though, you know, it's not always obvious right away.
I want to add to that, Catherine, a little bit. And I completely agree with what you're saying about public pressure. You know, if you're the governor's staff, there's only a certain amount of attention that you have, right? And if a bunch of people are continuing to try to get in touch with you to talk about the PolyMet permits, you're going to have to do something about it. You can't just ignore it in the same way you would for, something that you don't even know about. So getting the attention of the governor and the governor's staff is super important. I think that's an underappreciated way of changing the course of government decisions.
Yeah, and another way of saying sort of what you guys are talking about is that ultimately a lot of these big decisions are political.
Yeah.
Yeah. Yeah.
So definitely don't allow the takeaway to be that you shouldn't comment. You absolutely should.
Yeah.
People have to remain engaged on these big issues. That's really the only way that we're going to win.
Yeah. There's a question about, does the EPA kind of overrule the PCA? Which I think the person's asking, like, who's the decider on PolyMet in these cases? Is this really like where EPA can come in and sort of reverse things, or does PCA have all the authority?
I can try. That's a really interesting question. On enforcement, for instance, when an inspector goes to a facility and sees a bunch of things wrong, the EPA can overfile and come in and say, well, that enforcement action that the state took is inadequate. We're going to bring a federal case against this facility. So there's always that background ability for EPA to enforce. Obviously, they can't enforce every case. Most of them are enforced by the locals. On permitting, there's a similar authority. It's used less, but there is the ability for EPA to say to a state, like, you're doing your permitting wrong. Like, we're gonna come in and change. Well, really what happens is they pull their program and they say, we're gonna take over this program because you continually do it wrong. So there is EPA oversight both on enforcement and permitting. And EPA sometimes does comment on individual permits and says that, you're doing this permit wrong, you have to change it. In this case, that did not happen at the time in 2018.
So generally, when we were describing how EPA, the federal government, can delegate programs to states, which has been done with the Clean Water Act and the Clean Air Act now in Minnesota, EPA still reserves the authority to object.
Right.
And that's actually what was at issue, in the controversy over the water permit. So EPA staff, the people who had the technical knowledge about the effect on water quality of this proposal, were essentially getting ready to file a letter with PCA saying, you got to change this up or we're going to be objecting. And the political muckety-mucks from the Trump administration didn't allow them to send the letter. And the PCA said, oh, please don't put anything in writing, right? So yeah, what happens at EPA is super important on all of these permitting decisions. And now that we have the Biden administration, that also makes me a little bit more hopeful. Like, again, going back to this wetland permit and the Fond du Lac case, and we also have a case that's pending, that program has not been delegated to the state. So that's an EPA, and that's why those cases are in federal court. The cases are against EPA's permitting of the project. And so the new administration can take a different tack there if they want.
So they could, for example, take the permit back or the decision and rethink it. Is that what you mean?
Yeah, they can settle the cases. I mean, there's a number of different options for them.
Yeah, there was a question about whether the administration might shift their policy on this. And I don't think we know, I don't think we have enough information to say that yet. But I do think the opportunity's there if they want it. There's a question about Glencore, and Glencore is the parent company of PolyMet. The time that the permit was issued, they owned about 37% of PolyMet, and then later acquired far more, and are now a majority owner. And what do we want, a multinational corporation like this operating in Minnesota?
Is that the question?
That's the question. I can take a stab at it if you guys.
You should take a stab at that one, Catherine.
Okay. I mean, the issue with Glencore, isn't so much that they're Swiss. I don't have a problem with the Swiss necessarily, but it's really that they are, it's really that I mean, Glencore is a huge company, like bigger than you can imagine. They have mining interests as well as a lot of other commodities. And that's what they do. They buy and sell commodities. They have a fleet that's like bigger than the US Navy, and they shift commodities around the world to try to get the best prices, is how I understand their business model. And they do own some mining operations that are quite questionable and have real problems. And so I do think that raises concerns about whether we want a company that has a poor record on mining elsewhere to come and mine in Minnesota. There's also a question about whether we want them on the permit, because they're a parent company, now they're a majority owner, really not a parent company, that's the wrong phrase, they're a majority owner. Shouldn't they be held responsible if there are problems at the mining operation, is the question that a lot of folks have asked. And it's a question that the courts are asking right now on our permit to mine case. And I think it's a really good question. I do think that the idea of trying to recover money, like let's say there was an accident at the PolyMet site, trying to recover money from a multinational corporation like Glencore would be really hard, because they've got a bunch of different corporate entities. Trying to chase that money down through their corporate structure would be hard. And that's a big part of why we also want to see a significant financial assurance package, because you've got that money in hand, right? And you don't have to, I mean, I, for one, would not want to be the Minnesota Attorney General, whose job it is to try to navigate the Glencore corporate structure and find, where the money went if we need to recover for some kind of damages in the state. I think that would be a very hard job. So that financial assurance is also a really important part of it. And the other thing I want to say about this is that the Glencore and then Antofagasta, which is the investor behind the Twin Metals, the fact that these companies have challenging or poor mining records elsewhere really exposes, I think, some of the hypocrisy of some of the arguments we hear in favor of opening these mines in Minnesota. Specifically that we can do it more safely here because we have better laws, and we should do that because we consume these products. Well, first of all, it's not at all clear that we have better laws, and I think this litigation that we've engaged in absolutely exposed that. There are other jurisdictions that have much stronger laws, for example, on tailings dam safety. And they're not the ones you might expect. They're like in South America. So that's one thing, but then also for them to say, well, we're operating risky mines elsewhere and causing problems, but if you let us come to Minnesota, we'll do better because you'll make us, is really a strange argument in my opinion. And I think if the mining industry is serious as a whole, that they want to do better, they shouldn't do it by coming to a jurisdiction like Minnesota. They should do it by building their own set of standards so that they build safe mines everywhere they mine. And then if they do that, a bill like Prove It First wouldn't be a problem for them at all, because they would be saying, hey, we hold ourselves to a high standard of safety and fair labor and environmental protection everywhere we go. And hey, Minnesota, we can do it here too. And then that would be a really different conversation than the conversation that we're having. Sorry, end of reading.
Yay, good point. I endorse that.
Good point. Yeah.
Catherine, I'm just noting the time.
Yeah.
And I think that we said that we would be done in 45 minutes or so. So maybe we want to invite people to get in touch with us over email if you have further questions. I'm happy to respond. Evan's probably happy to respond too. So you can find our email addresses on our website.
Kevin, there is a question about, can we share the federal court decision you were talking about for Fond du Lac?
Yeah. I would be happy to email that person the decision. I'm not sure how to share it from here.
Okay.
But we can certainly get that out.
Wonder if we know the person who posted that. I'm sure there's a way to share that. Yeah.
It's in the Q&A, guys.
Okay. Well, thank you. We will figure that out. Thank you so much for joining us here today. If you are a donor and a supporter, you helped make this happen, this win, and more wins hopefully to come. And if you are not, then please consider becoming one. There's the link in the chat to mncenter.org to our donate page. You know, we've been working on this case since before I started at MCA, since 2005. And, you know, we're far from done here. These are difficult issues, and they're, you know, long-term, they require long-term investments. And you make long-term investments in us when you continue to support us year after year or month after month if you're a sustaining donor. So thank you.
Yeah, thanks everybody.
Yeah, I want to say thank you too. I really appreciate you guys and the supporters and everyone else. These cases are really a big deal, you know, and we're going to continue working on them. So thank you.
Yeah. Have a great weekend, everyone.